Court is calling 2025 CR 007106 State versus Christina Louise Shad. Is that how you pronounce your last name?
Yeah.
All right. That party's announced.
Duffy Pitlock for the state of Texas, Your Honor.
Jay Moritz, Your Honor, from the Shad.
And are you Ms. Shad?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Shad, did you review the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Shaw, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
I'm sorry, is the court admonishments
It's this document. It tells you everything, what you're charged with, and it tells you the range of punishment, and it tells you what your rights are.
Okay.
Did you review that with him?
Yes.
And did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
All right, so you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from a $10,000 fine and anywhere from 180 days up to 2 years in the state jail facility. If you have a plea with your attorney and with the state, the court does not have to follow that agreement. If for any reason the court does not follow that agreement and give you more than you bargained for, the fact that you've entered a plea will not be used against you, and we can start over. Do you understand?
Mhm.
And you can withdraw your plea. Do you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Mhm.
Did you understand that?
Yes.
Did you understand by entering this agreement, you're giving up those rights?
And
You understand that you're given the rights to a trial by jury.
yeah.
All right, so I'm going to take it step by step.
Okay.
And has she been before me before? Why do I remember her?
No, the first time she had some cases years ago where she was ruled incompetent.
Okay. All right, so you have a right to a jury trial. Do you understand?
Yes.
All right, so what that means is 12 people would sit on a jury. 12 people, neither you or the state knew beforehand. And the state would call witnesses. Do you understand?
Mhm.
You're gonna have to say yes or no.
Okay.
Right. And the state would call their witnesses, and then your attorney would be able to ask them questions, or you could ask them questions. Do you understand?
Yes.
All right, so because you're entering this plea bargain agreement, the state is not going to call any witnesses, and your attorney is not going to have a chance to question any witnesses, and you won't be able to question any witnesses. Do you understand?
Yes.
All right, do you understand that if the state were to call witnesses, the state couldn't say, I'm going to call Ms. Shad as a witness. So do you understand that?
Yes.
So you're giving up your right to remain silent also by entering into this plea bargain agreement that you've reached. Do you understand?
Yes.
So do you want a jury trial? Yes or no?
No.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Judge, I've had a Zoom with her at the jail and we discussed things.
Do you believe she has a rational, a factual understanding of the charges against her?
In my opinion, at this time, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Shad, has anyone threatened you, forced you, or coerced you to get you to enter this plea?
No.
Anyone promised you anything other than the plea bargain agreement that you've worked out?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, so this is what I'm being told your plea bargain agreement is. It's 180 days in the state jail facility. You're not applying for any type of probation. And there's to be $60 to be paid to the Bexar County Laboratory. Did you understand that?
Yes.
And that $60 is what they say it costs for them to do the drug testing. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Judge.
Did you review the waiver of appeal paragraph with your attorney?
Yes.
Did you sign it in both places?
Yes.
All right. So by signing that, if I follow this plea bargain agreement, you can't come back later and appeal that. Do you understand?
Yes.
The only rights you have to appeal is if your attorney has filed pretrial motions, such like maybe a motion to suppress or something like that. And I've made a ruling on that. Do you understand?
Yes.
Counsel, have there been any motions that you filed where the court has made a ruling on them?
No, Your Honor.
All right. Then to the charge, how are you going to plead? Guilty, not guilty, or no contest?
No contest.
All right. State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
No objections, Your Honor.
Thank you. All right, did you review the stipulations and waivers with your attorney? That is, it consists of police reports, the reports from the chemist on whether or not the drugs tested positive for any type of drug. Did you review those documents with your attorney?
Yes. Yes.
All right. So I just want to make sure you understand. The state is presenting their evidence now by not calling witnesses. They're just bringing in police reports for the court. Do you understand?
Yes.
Now, if you want to, you can force the state to bring in witnesses to say that you committed this offense beyond a reasonable doubt. Do you understand?
Yes.
So do you want them to present witnesses or no?
Yes.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes.
All right, anything you wish to say on behalf of your client?
No, Judge, we've gone over this and at the time of the incident, it appears that she was under the influence of narcotics. And I've conferred with her and believe that she understands everything that she did, and her competency is intact right now.
All right, the court is going to sentence you to 180 days in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's to be no contact with the Valero located at 12111 O'Connor Road, San Antonio, Texas, 78233. And there's to be restitution to the Bexar County Laboratory for drugs testing in the amount of $60. Is there anything else with regards to sentencing?
No, Judge, she's been in custody since 4/16/25. We're asking if she would, if she gets, or if you get the paperwork from the state jail facility to allow the 80/20 credit.
All right, what will end up happening is that's going to depend on any programs that you're participating in. If you're participating in the programs and internalizing everything, I will strongly consider giving that to you. So whether you receive that or not will be completely up to you and your actions. Do you understand? Yes or no?
Yes.
Okay. Did you review the trial court certification of defendant's rights to appeal with your attorney?
The one you signed.
Yes.
That's right.
All right, because you entered into a plea bargain agreement, and because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing, Ms. Shad. It appears to the court that you have a drug problem, right? When you are released from custody, if you cannot find a place, be it a sober living house, or if you have a problem with your sobriety and you just need some extra help with it, if I'm still here, you can come back here and I'll pick up the phone and find a place for you, okay?
Okay.
So only one or two things can end up happening if you continue on this path. Either you're going to end up in and out of somebody's jail or prison, or either somebody's going to have to identify your body. You understand?
Okay.
And I don't want that for you. Okay. All right. Good luck to you.
Thank you.
You're welcome.
Good luck.
All right, let's talk about that. This was the case of State v. Christina Louise Shad, and it was one of those hearings where the Judge Boyd really went the extra mile to ensure every yes and no meant something. From the outset, Judge Boyd showed that signature combination of patience, clarity, and firmness. She didn't just run through the standard plea colloquy. She broke things down in plain English, asked follow-up questions, and even paused when it seemed the defendant, Miss Shad, was unsure about her rights or responsibilities. You could feel the judge trying to balance the letter of the law with genuine concern for the defendant's comprehension, especially since it was mentioned that Miss Shad had previously been ruled incompetent in older cases. Miss Shad's responses were mostly compliant, if at times hesitant, lots of and long pauses, but to her credit, she never got defensive or combative. She answered when prompted, admitted confusion when it was honest, and seemed to be trying to keep up, even if it was clearly a lot to process. Her defense attorney played it steady, confirming that they'd reviewed all documents and that he believed she understood the charges and was competent to proceed. No courtroom theatrics here, just a low, quiet rhythm that matched the gravity of what was being decided. And when it came time to plead, Christina opted for no contest, which the judge carefully accepted after ensuring she understood the full weight of it. The state presented its evidence via stipulations, and the court accepted it without drama. The judge ultimately handed down a sentence of 180 days in state jail with credit for time served, and even made a strong recommendation for the Therapeutic community program, clearly hoping for a long-term turnaround. One small but heartfelt moment came after the sentence, when Judge Boyd spoke directly to Christina, telling her in plain, compassionate terms that the path she's on could only end two ways, neither of them good. And then she offered real help. Call me if you're out and need a place. That's not something you hear every day from the bench. The courtroom vibe was calm but serious, and the message was clear. This wasn't about checking boxes. It was about making sure the defendant had one more real shot at getting her life together. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.